to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm here with attorneys Nathan Seltzer and Clayton Calvin, as well as our Director of Litigation, Chance Weldon. We are here today to talk, well, we're still kind of wrapping up, still slowly tying up the loose ends on the Supreme Court drops from this session.
It's almost as if they dropped the majority of the big cases on the last week.
And the ones that we had to take at like an entire podcast for one case, that was all at the same time.
Yeah, right.
But we're circling back on
tariffs, I guess. That came earlier. All the same, we are going to clean up today with Pung versus Isabella County. But before we get there, I want to talk about one of the predicate cases, a case that came along in 2023, Tyler versus Hennepin County, which admittedly not probably news to, I would imagine, most of our listeners, but it lays the groundwork for this case for Pung versus Isabella County in some really important ways. And it's very different in some really important ways. And I think that it's really important to talk about those distinctions. So before we get into Tyler versus Hennepin County, right before we started filming, someone at this table suggested that some of us might be more mostly originalist than others. And I really want to know who you're pointing fingers at, Chance Weldon.
We have a right to, confront our accusers.
I'm just saying that I'm the most mostly originalist.
The most
That's
mostly
weird,
originalist.
I'm 100% originalist.
Yeah.
Absolutely none of. Didn't you tell me earlier today you think that the state should ban social media?
Wow,
I don't know
just
if
under the bus people go.
I have so many questions, Clay.
I didn't say that, for the record. She's twisting my words.
I don't know. I think that it's probably important for you to defend yourself on that one, but not right now, because right now we have to talk about something else
for minors in certain
wildly
cases. Anyway,
unoriginalist that the state was doing. Tyler versus Hennepin County deals with a tax sale. So before we get into these cases generally, I think it's probably good if we start with what tax sales are and how they function and how they work. 10,000 foot view. If you don't pay your taxes on a piece of property that you own, the state can place, and this functions a little differently in every state. So it's a creature of state law, varies a little bit. The state can place a lien on your property in the amount of the tax plus fees and whatever else, interest, delinquency, whatever. They can place a lien on that, and if you don't pay that tax within the right period of time, you don't redeem your property, they can foreclose on your property and sell your property in an auction on the open market. And that has been the standard practice, as far as I can tell, for a very, very long time. So that's the kind of the groundwork of where we're coming from in all of these cases today, is that same basic framework.
And they on the open market could mean a lot of different ways that they would have the option to sell it, but typically what they do is they sell it at an auction, and whoever shows up at that auction and happens to want to bid on it can do so, but that price is not going to be what you would normally get. When we think of open market, we think of realtors, and you're going to go tour the property.
It's not like that at all.
Yeah, but if you go into a tax sale, or an auction, a tax auction, you've never seen the inside of that property, so it could be trashed. There could be tenants living in it, or the former owners living in it who don't want to leave, and you would have to evict them if you bought this property. And maybe you don't want to do that because it's icky to evict people that just lost their property to a tax sale. And so for that reason, these properties at auction often go for substantially less than what they would go for if you did hire a realtor to sell the property and you were doing it the open market normal way.
All right, so all that background in mind, let's start with Tyler versus Hennepin County. So in Tyler versus Hennepin County, Ms. Tyler was a 94-year-old woman who owned a little condominium in Hennepin County, Minneapolis, I think. She defaults on her taxes. She's got $2,300 in unpaid taxes. The county takes it to a foreclosure sale, just like we were through that same process we were just talking about, and they foreclose on it, and they end up selling the condo for $40,000. Now, with taxes and fees, she actually owned about $15,000. So really, there's this $25,000 that's floating around in the background. And Hennepin County says, cool, we get $25,000 out of this.
This is a great deal for us.
This was such a great deal for us.
And a bad deal for the 94-year-old woman.
And this poor 94-year-old woman doesn't get her $25,000.
I think it's $25,000 above what she actually owed.
Right. She owed $15,000. The county unequivocally was entitled to that $15,000. that they received in this sale. But in excess of that, the property sold for $25,000 extra dollars.
And that was a windfall to the county.
Right. And the question is it a taking? If the county gets that extra money, is it a taking? The secondary question that's sort of addressed, kind of not really addressed in this case, is the Eighth Amendment question of, is that also then an excessive fine for her failure to pay her taxes?
Yeah.
Was this I think this was brought by one of our friends at a fellow public interest organization like ourselves. I think it was it the Institute for Justice? Or was
it was Christina Martin over at the Pacific Legal Foundation. Okay. She was a fellow with me whenever I was a fellow at Pacific Legal, and she crushed it. Her oral argument was great.
Amazing.
Yeah. And this was a resounding win for them. Like, this was unanimous decision.
Unanimous opinion. Yeah.
With a hammer on the head from Justices Gorsuch and Jackson, and also this would be an Eighth Amendment violation if it wasn't a taking. So it was a great win for PLF.
It helps when you have your plaintiff is a 94-year-old woman. I mean, that's a bad thing.
Good
it's
facts
for a lawyer if you're representing her.
Good facts make good law, and this was a situation where the court got it right. And what's important to point out, though, is this was not a one-off in Hennepin County.
Yeah.
The reason this made it to the Supreme Court wasn't just those bad facts. It's that this is something that local governments and state governments were doing all across the country. This sort of home equity theft where they would, sometimes for very minor tax liens, $1,000.
Yeah, $2,300 is the underlying tax here.
Yeah, and they were taking sometimes hundreds of thousands of dollars in equity and just pocketing it. And they were winning in the lower courts. This was not a situation where Ms. Tyler had won below and then the appeal went up. Like the lower courts were ruling against property owners. And the government's arguments in the case were very aggressive. One of the arguments, which is actually one of my favorite points from oral argument, was that the government tried to argue that Ms. Tyler did not have standing.
Yeah, that's the first section of this, because of course it is.
And
Thomas
just
had some words about that.
Yeah, Justice Thomas was actually just sort of flabbergasted. It was one of the few times you'll see Justice Thomas flabbergasted. He's like, I would and he pauses. I would think that
a pregnant pause.
That the reason she's injured is you've taken all of her money.
Her house.
$25,000 of it. I think it probably bears just talking about this argument and the way that the government framed it, because it's a really good illustration of how quick the government is to jump to standing on everything. So the government's argument was, well, we can tell from other records that she had a mortgage at one point in time, and she hasn't proven that she's finished paying her mortgage and maybe some other debts that are associated with it. So really she got a windfall because now she doesn't have to pay that mortgage anymore. And if she got a windfall, that means she doesn't have standing because she's not injured. To which the majority was like, yeah, absolutely not. She still owes the mortgage maybe, and she could be $25,000 closer to paying that off if you give her the $25,000 she is owed.
Yeah, if the thing that young law school students and young attorneys learn very quickly is that standing as an analysis is different from the merits of something. So, So you're only asking if she is injured enough, something happened in her life factually such that she could go to court to then discuss whatever it was, whether she has a mortgage or doesn't. And you're supposed to divorce those two things, but the government doesn't, and bad law students don't either.
I didn't realize the government made the argument that she doesn't have to pay her mortgage now that we seized her property. That's not how that works.
That's not how that works.
It extinguishes the mortgage, but she still owes it. It just doesn't. They just can't go after the property anymore.
Yeah.
They can go after her all they want.
Yes, also mortgages. You're right.
And then the government also made this argument in the case that, and this is something we see all the time and it drives me crazy, and the Supreme Court rejects this rightly as well. But they said also you can't bring a takings challenge because this whole tax seizure regime, it was already on the books when you purchased your property.
Gosh.
And therefore it was a background principle of property law. And so the fact that we took your house and kept $25,000 of excess value, you haven't really been injured by this at all because that statute was already on the books when you purchased your house.
Yeah, you should have known.
And this, folks, is how you lose from a unanimous Supreme Court 9-0.
But those were successful arguments below the
And
That's how you win.
that's still an
Another
argument
court.
that we hear in every single property case
Yes.
we file. That is the argument that we get, whether it's on social media or in briefs from opposing counsel or even in opinions from lower judges. It's across the board. The argument that we hear is, well, you came to it.
Yeah.
You chose
knew the
to buy here.
unconstitutional law was here before you
Right,
got
right. So you can't challenge the Constitution.
So the freedom
So
is
why is that
taken.
wrong, Chance?
Well, because just like every other right in the Constitution, we wouldn't think that that was a defense. You know, if there was a city that, for example, prohibited all Catholics, no one would raise the argument like, well, you knew that law was on the books when
What
you
were you
moved there.
doing
So,
in that non-Catholic?
so I guess the First Amendment doesn't apply. If a government is acting in excess of its constitutionally delegated authority, it doesn't matter that it was already on the books. The Supreme Court held that in Palazzolo. The Supreme Court held that again in Tyler versus Hennepin County. And, you know, courts have held it over and over again when it goes to the Supreme Court. But in the lower courts, and particularly on social media with individuals, this has some intuitive appeal.
Yeah.
And because of that, it keeps coming up over and over again, but it's been rejected over and over again. And it would be, I don't know, a huge victory in my career if at some point I don't have to keep briefing it.
Yeah.
It's like a somewhat valid argument in the context of maybe private parties,
Private
and like
nuisance,
torts
yeah.
and nuisances and causes of action and equity and stuff. But when it comes to constitutional rights, I mean, the whole predicate here is that your rights precede the existence of the government
Yes.
in the first place.
But even
So
with private
the
parties,
timing doesn't matter.
yeah, but even with private parties, if someone's like dumping toxic waste onto a property and then you buy that property, you can still say, hey,
That's
stop
also
dumping
true.
toxic waste on
Only
my
in
property.
certain
Yeah.
situations.
Yeah.
Yeah.
It's not like taking subject to something that's unconstitutional or illegal never made any sense.
Yeah, and it's one of those things like no one would say, for example, that, you know, Mr. Sweat couldn't challenge the racial segregation at
Right,
the University of
right.
Texas in 1960 because he knew it was he knew it was segregated when he applied there.
Yeah.
Everyone would think that's a ridiculous argument.
Yeah.
And yet in the context of property rights, we still have to litigate it in every single case. But
Well, and it's because of that same problem that we run into again and again and again in these cases, which is that property rights are treated as secondary.
yeah.
We assume that property rights are subservient to other kinds of rights, and they're just not. If we behaved as if they got the same level of protection as the Second Amendment, let alone the First Amendment, we would be in a very different place as a country. And we'll come to some of Justice Thomas's feelings on that when we get to his concurrence in Pung. But
Yep.
property rights are every bit as valid
Yep.
as First Amendment rights, as Second Amendment rights. We just are more mealy-mouthed when it comes to defending them.
Yeah, I was going to say there's a lot of rights that are not even necessarily like stated expressly in the Constitution that we afford a lot of respect to and should, but property is like literally glaring. That word property is
It's
right
actually in there.
Yeah.
It's in the Constitution. And that actually is a good segue into the meat of this case, which is the takings clause, very much in the Constitution. This is not
Yep.
a substantive due process issue whatsoever. This is quite simply, if the government takes your property, it must compensate you for it.
Yeah.
That is the crux of the takings clause. So there's an interesting dichotomy in this case, because in Hennepin County in particular, the court is not real clear whether the taking in question is the taking of the property, which is being sold and has been forfeited, quite literally, that's the term, it's been forfeited, or it's the taking of the money in excess.
Right.
And I think that the way that it's written, I think what the court is saying, whether they realize it or not, is that the taking in question is a taking of money. Is that common? Is that usual that for the taking that we're talking about to be a taking of money?
It can be, particularly when the money's in lieu of property. It's not particularly common because you get into complicated questions about, like, say, taxes, for example, or money in our, taxes aren't necessarily takings.
Although Nathan brought up a good point earlier that taxes are, they're uniform. They've gone through a legislative
Yeah.
process and everything. It's not just like the county coming and seizing something.
Yeah.
Yeah.
But yeah.
But when you start talking about takings of money, there's interesting downstream effects.
Yeah.
If you say that every time the government takes money from you, it's a taking. Another interesting place where this might appear is in restitution in criminal law.
Yeah.
If the government is going to take your money and say, hey, you've injured this person, you need to pay for their medical bills now, is their taking of that money now something that you should be entitled to compensation for?
Well, this is, it's an interesting point. And, this is why I think it was wise for them to bring both a Fifth Amendment challenge and an Eighth Amendment challenge, because you have to just figure out how you're going to characterize it. Right. And so when you're talking about taking the excess compensate or failure to compensate, so that you could argue that you've taken the house and then the compensation for the house, like who gets that market value once it's been auctioned. So if it's a taking, you can analyze it that way, or you can analyze it as a taking of the money. You could also look at it as a punishment, which would be like restitution. So like, or some other thing in criminal law where you have like criminal fines or criminal fees. And then you would say, is that proportional under the Eighth Amendment? And what our friends at PLF did here in this case is they argued both.
Yeah.
And they said, like,
alternative.
It's either a taking, in which case we're entitled to just compensation, and this is not just compensation, or it's, a punishment. And if it's a punishment, then it's an unjust punishment or an excessive fine under the Eighth Amendment. Mm-hmm. And so having those two streams available, I think, was clever.
Yeah.
Kind of putting them between a rock and a hard place a little bit.
I don't like characterizing the taking as the taking of money after the sale of the property, because it moves the taking forward in time and it assumes the sale, everything that happened in the sale was okay. The taking was like what she lost, what Ms. Tyler lost was her house.
Yeah.
She didn't lose her money. She'd much rather have the house than the money. She lost money after that, but she first lost her house, and I think that's the taking.
And the value of the house is represented by the money.
The value of the house is represented by the money, but she'd rather have the house, right? Right. And so, like, I think keeping that in mind is important. That if we go forward to the taking, then if it's a depressed value, which we'll get to in Pung or something like that, then the just compensation looks different, because what the house was worth before it was foreclosed on would be more than what it was worth after it gets foreclosed on.
It also makes that Eighth Amendment argument that much sharper if you couch it as the taking of the land itself, especially when you're saying, okay, the penalty, the thing that you are being penalized for is failing to give the government $2,300. So we're going to take your whole house for it.
Yeah.
Like, all of a sudden it just crystallizes that Eighth Amendment argument of, wow, this is unjust. That for $2,300 she's going to lose her condominium. Like, that is truly, truly wild. Yep. This is an interesting case from an originalist perspective, because it's an example. I'm not going to say a particularly rare example, but this is an example of Justice Alito during originalism, and I don't think he does it all that frequently, at least not as full-throated as he did here, going all the way back to the Magna Carta and saying...
Was the majority? I thought it was Roberts that wrote the majority.
Maybe this was
Roberts.
One
is Rob.
I'm so sorry.
Tyler is Roberts.
Tyler is Roberts.
Justice
Pung is Alito, though.
Yeah.
Oh, yep, I'm backwards. This is Justice Roberts doing originalism and going all the way back to the Magna Carta and back to Blackstone and saying, this was such a problem that when the Magna Carta was written, the landowners in that era were looking at the government, looking at the king and saying, this is one of those rights we're going to insist on. And if you don't sign this promise not to take money in excess of our debt, that will chop off your head, quite frankly. That
actually led to a really interesting oral argument exchange.
That's in the Magna Carta too. It says, comma, quite frankly.
Yes. We will chop off your head, quite frankly.
There was it's been years since I listened to the oral argument, but I remember we were sitting and listening to the argument. There's this great exchange with Justice Gorsuch and the government's attorney. And the attorney is citing something from the ordinance of something from the 1100s or like 1000s. Mm-hmm. And then Gorsuch interrupts him and he says, but there was this interesting thing that happened in the 1200s, wasn't there? It was Magna Carta, wasn't it? You're citing something pre-Magna Carta to me.
Yeah.
It was a little revolutionary, wouldn't you say? Maybe changed the course of history a little bit.
Yeah, I mean, and it's an interesting thing about, like, with originalism, you're not just citing old stuff.
Yeah.
Yep.
You have to justify why that old stuff would matter to the original meaning of the Constitution. And just because it's old doesn't mean that it's relevant, right? Like the Magna Carta was a big deal to the people who wrote our Constitution. Mm-hmm. And so if you're citing something that actually is one of the grievances that triggered the creation of the Magna Carta, maybe that's not the best evidence of what our Constitution protects.
Yeah, like maybe you don't want to cite British laws that led to the American Revolution against the Constitution.
Stamp Act. Yeah. Your Honor, the Stamp Act clearly said.
Yeah.
Exactly. This is one of the things that was incorporated or that would have been so well known to the authors of our Constitution, the drafters of our Constitution, as they were creating it. They would have understood this to be one of those principles that needs to be incorporated into our Fifth Amendment. When we talk about takings, we are in fact talking about the Magna Carta. That's what they're saying. At the end of the day, this is actually a fairly simple assessment.
Yep.
And I think it's probably pretty intuitive to most of our listeners that, the government is not entitled to this $25,000 extra dollars. There's not even a colorable argument that they would be. The one argument that the state raised that gets some airtime from the court is this argument of abandonment. They argue that, well, we've decided that if you fail to pay your taxes on your property, that you've abandoned your property, and abandoned property can be taken by the government without compensation, because just general background principles of abandoned property and how all of that works.
Never mind the fact that you're still living in it and you're still sleeping and eating and paying your mortgage and everything.
Yeah, this kind of made me think of the Hawaii gun case of Hamani, which I think it was Hamani. Yeah. With that question of, can the state just say, we're going to legislatively change the background property law principles? And the background property law principle that we're going to change is the definition of abandonment, that old common law definition. And
it's
the
been
court
around
says,
for like hundreds of years, and you're just...
property law is not so flexible that you can just decide that it's something that it's not.
You can't redefine your way out of a takings claim.
You
basically.
can't redefine your way out of a takings claim.
Yeah, you can't redefine ancient common law terms. You can't redefine constitutional, especially when they bear on constitutional rights. Same way you can't, declaring something a nuisance, in fact, does not make it so.
Yates.
Yates.
Yeah, the Constitution deals in substance, not shadows, is one of the more famous lines, right? It is interesting, though. It's one of those things that, for all of our listeners out there, that to the extent they exist, that are government attorneys or that want to go and be government attorneys, we have a lot of friends that work at AG's offices and for solicitor generals, and they're great folks. But it's a good reminder of, just because you can come up with a creative argument doesn't mean that you should. And sometimes as an advocate, I think we can get blinders on to not step back from the case and look at the forest for the trees. And maybe that sounded like a great argument when you're talking about, like, oh, you knew it was there when you purchased it, or, oh, this isn't really a property, or like, maybe you don't have standing. You
abandoned this house when you didn't pay your taxes.
Or you don't have standing because you raised standing in every case.
Right.
I think it's a good point, and we do this too, is to have someone else, you step back and look at it, it's like, is this really what we want to argue? I mean, they took this woman's house. Are we really arguing that she doesn't have standing? Maybe we should present a different argument. I'm not saying don't defend, you have a duty to defend the state. I'm just saying that I think as advocates, sometimes we can all kind of get lost in sort of losing the forest for the trees, and government advocates do it a lot because they get away with it a lot in the lower courts.
And as an advocate for the state too, I mean, you're essentially like, it's a derivative of the fact that you're an advocate for the people.
Right.
You can't forget that. It's not just the state itself.
So did the state get to keep the $25,000 windfall?
They did not. Yeah. They did not. Unanimously, the court held that that was a violation of the takings clause, and that the just compensation requirement, oh my goodness, required that $25,000 to go back to Ms. Tyler.
Yep.
And then Gorsuch and Jackson just chimed in one more time, like I said, to hit the nail on the head and say, and also this was a violation of the Eighth Amendment.
Yep.
It wasn't necessary for the court to reach that holding, but it is necessary for Justices Gorsuch and Jackson to just say, it bears repeating that this also violated the Eighth Amendment.
Don't take the fact that we didn't rule on this in the majority as like a license to go forth and violate the, that you're in the clear with the Eighth Amendment when you do this kind of thing.
And I have a purpose for this. I'm going to go into just a couple of the reasons that Justice Gorsuch gives for saying that this violates the Eighth Amendment. He says that the district court concluded that Minnesota's tax forfeiture scheme was not punitive because its primary purpose was remedial, aimed, in other words, at compensating the government for lost revenues due to non-payment of taxes. However, that primary purpose test finds no support in our law. Because sanctions frequently serve more than one purpose, this court has said that excessive fines clause applies to any statutory scheme that serves in part to punish. So that's coming back to, I'm going to butcher this, Badgicasian, which says that the question that we're looking at for Eighth Amendment, for Eighth Amendment purposes is any part of this punitive in nature, not just is this something that is exclusively punitive or primarily punitive, but punitive at all. And so that's the standard that is recited there by Justice Gorsuch, and that'll be relevant in Pung as well.
And so to put just like a little bit of meat on that bone, just real quick, it would be, for example, if there was something that said I had to compensate Nathan if I took his laptop, I had to return the laptop. If under Gorsuch's standard, if I also attach a $5 fine, that whole thing becomes punitive, even though the majority of like returning the laptop is restorative, if it contains any element of punishment, then it triggers Eighth Amendment scrutiny. That doesn't mean that a $5 fine would violate the Eighth Amendment, but at least you're in Eighth Amendment land as soon as there's, an ounce of
It implicates the Eighth Amendment.
Yeah.
We need to decide if it violates it. Yeah.
It's also interesting the evidence that they look at to decide whether or not it's punitive in purpose. In this case, there were some findings from the district court. It was the judge's observation, actually, that this certainly serves a deterrent purpose. And because the district judge made that observation, that was sufficient for Justice Gorsuch and Justice Jackson at least to say, clearly that's part of what's going on here, and therefore this is punitive in nature. It didn't even have to be written into the language of the law necessarily. It was just as soon as the judge said, this is obviously here for a deterrent purpose, the Supreme Court latched onto that and said, that's correct.
I mean, it's the same sort of thing. You can't label your way out of a constitutional violation. I mean, even if they had the exact same, statute and the state had written in there, but this isn't punitive at all.
Right.
The court's not obligated.
Right.
To actually just adopt whatever the government says.
We don't have to listen to you every time. So, all right. Okay, so let's move on then to Pung versus Isabella County, because there's a question that is unanswered in Tyler versus Hennepin County. And this is one that our tax attorneys, I'm sure, will be well familiar with. And that is the question of, okay, but what if the sale of the property is well below the value of the property? And I'm using value there intentionally because what kind of value we're talking about sort of at issue here. But frequently what happens, and Nathan, you might be able to go into more detail on this than I am, frequently what happens is they will put property in a tax auction for the amount, like starting bid is the amount of the tax. So if we assume for purposes of this discussion that in Tyler versus Hennepin County, the starting bid would be that $2,300 or maybe $15,000 when they know that property is worth $40,000 and maybe they get $16,000, $17,000, $18,000 for it. What do we do if that auction price and the money that actually comes in for the property is far below the value of the property?
Yeah, and that's exactly what happened in this case. So the Pung family owed, well, actually they didn't owe, but I won't get into that part.
We'll circle back on that one.
Yeah.
I mean, it's
I'll get into it.
relevant.
So I will get into it then. I'll start with that.
Yeah, start there.
So the Pung family lives in this house, and in Michigan, like Texas, you get a property tax exemption if you live in the house, so you get a lower tax rate. And in Michigan, and what it sounded like in this case is that they actually didn't owe any tax on this property because of the exemption, so they didn't pay it. Isabella County assessed the tax anyway. And
as if it were like their second home, basically.
As if it was a second home. And they did own multiple homes, I think, but they were living in this one. So they assessed the tax anyway. So the Pung family did what Michigan law requires, which is they went and challenged it administratively through a process in Michigan. And they won at every level challenging that tax assessment. And the Michigan administrative law system, an administrative law judge eventually said, you do not owe the tax. This began in 2010. They won all the way up until 2014. They get up on appeal. They come through, and so this goes into the Michigan state court system. They win there in the district court of Michigan, and then or the trial court of Michigan, and then it goes up on appeal to the Michigan appellate system. They win again in 2014. So there's been every step of the way the Pungs have won, showing that they don't owe this tax. It's a little over $2,000. I'm going to use round numbers just so our eyes don't roll back into our head. $2,000 that they don't owe. In 2015, despite all these rulings, the Isabella County has
2012. It actually happened in 2012.
Yeah, but in 2015, you're right. In 2012, that's when the assessment happened. But in 2015 is when they actually foreclose.
Yeah.
So after they've won all the way up, they continue the foreclosure process and finish the foreclosure in 2015, take possession of the house.
And I want to read just kind of how this panned out according to Justice Thomas.
Yeah.
So while this is going through the system, the tax assessor is levying these 2012 taxes. So here's what he says about the tax assessor. The tax assessor, however, chose not to respect the court's decision. I don't care what he says, she said of the judge who had ruled for the Pungs. Although nothing had changed after the tax tribunal's decision, the tax assessor purported to tax the Pungs in 2012 what would eventually amount to $2,242 for those same additional second home property taxes, related penalties, and interests. Even a decade later, before this court, the county could not substantiate a legitimate basis for imposing this tax. When asked at oral argument, the county's attorney said, "I don't know what the township assessor's reasoning was." The tax assessor imposed the additional tax in a manner that would make it more likely that the Pungs would become delinquent. The original tax bill sent to the Pungs for 2012 did not include the additional tax. The tax assessor imposed the additional tax only after sending out the original tax bill. They go in a little bit to some of that background information. This additional improper amount demanded by the township is apparently the only quote-unquote unpaid tax in the Pungs' history.
You don't hate the government enough.
Yeah. This is the clearest example I think I've ever seen written out of, oh my gosh, why is qualified immunity a thing?
But it's just,
why is qualified immunity a thing?
The amount of hands that has to pass through. This is, as we were talking about earlier, like step back if you work for the government, if you're the attorney who's litigating this case, and say, this is what we're doing? We had an order that said that this is not a valid tax, and now we're going to impose this and take this family's home. This is what...
I don't care what the judge said, is what this tax attorney, this tax assessor said.
But remember, in Michigan, in order to foreclose, there's also a process for that too.
Yeah.
So there's a parallel state process. While the Pungs are winning every state of the way, saying they don't own the tax, there's a parallel state process for the county to foreclose on that property, to eventually seize the property that's going on at the same time. And those judges aren't talking to each other. Yeah, they're saying, that the process is being followed for foreclosure, assuming that they actually owed the tax the whole time. So they never actually, part of the determination, because it's going on in this other case, is not whether they owed the tax that's being foreclosed on the property being foreclosed on.
The fundamental validity of it is not
there's
in front of them.
Yeah, so like eventually in like 2018, the Michigan appellate system says, the foreclosure sale is final and they've lost their property, and that was correct, even though there's another judgment saying that they never owed the tax.
The tax to begin with.
So Michigan's got a problem in its own court system anyway, but this is the backdrop for now this Supreme Court case. So with all that said, the Pungs are challenging, the Pung family is challenging whether this assuming this $2,200 tax bill is due.
Well, they're not even assuming that. One of the questions accepted on cert actually had to do with whether or not this was due. So that's there's a question
goes to the Supreme Court of the United States.
But it's a fact question. Yeah. So the Supreme Court didn't. Yeah, the Supreme Court didn't pass on it.
That's actually part of why it's sent back down.
Yeah. Right. So, but for most of the decision, we're just going to presume that they actually owed the tax that they definitely did not owe. But it's just easier to understand this decision.
Yeah, because the Supreme Court decides legal matters rather than cases.
Right.
Yeah. The question presented is different than the issue in the case. Yeah.
So wrapping this up, eventually when they foreclose on the house and they sell it at auction, it sells for $76,000. They owed about $2,000. So it sells for way more than what the property is worth or what the tax bill was. And then the county keeps the additional proceeds because, of course, they do. And at this time, Tyler versus Hennepin County had not been decided yet. So Isabella County also keeps the additional proceeds for a number of years until they eventually lose on that point.
After
Tyler. Yeah.
No, it was before Tyler.
Believe it or not, this was Eastern District of Michigan actually just deciding on their own that this is not actually okay, and that's fair. That is correct.
Yeah. That's nice.
But that was in 2022.
I'm proud of them.
Yeah, but the Eastern District of Michigan doesn't agree that says that they are not owed the additional value because even though it was sold at auction for $76,000, the county had appraised that house at $194,000.
Yeah,
and then they sell it at auction. It only sells for $76,000. And then that buyer at that auction turns around and sells it to someone else for $195,000. And if you're like all the numbers, they sell it for almost exactly what it was appraised for. So we have really good evidence this house is worth about $194,000 or $195,000. It sold for $76,000. So the Pungs are out about $120,000 of equity and their home.
Yeah, their place with it.
And so what we're discussing in this case is whether or not the Pungs are entitled to that $120,000 that they lost when Isabella County took their home.
Yeah, so the county made its own personal windfall was the 76,000, basically minus the 2,000.
Right, minus the 2, yeah.
And so that's the county windfall a la Tyler versus Hennepin County, which that issue was decided.
Right.
And then they turned around, they sold it to a purchaser, and that purchaser made another windfall. So now that extra windfall is the thing at issue in the second case.
And so, the question is,
talk about this as the follow-up case to Tyler.
Yeah. So the question is, do we look at the value of the house before the foreclosure procedure tanked the value of it, or do we look at the value of the house after the foreclosure procedure tanked the value of it? That's really.
And the reason that matters is under the Fifth Amendment, when the government takes your property, you're entitled to just compensation.
Yep.
And ordinarily, the way the case law shook out on what is just compensation, it's typically been the fair market value of the property. And so the question is if the government sells it for below the fair market value, do they still have to give you the fair market value, or is the whatever it's sold at the auction the actual fair market value for takings purposes?
And this makes sense. Like if you own land and the government wants to put a pipeline through your property, they will do an eminent domain proceeding it'll be a taking, and they'll issue you just compensation, and it's going to be based on the fair market value of whatever portion of your land they take. The government doesn't say in that circumstance, oh, we can't possibly calculate what the fair market value is. We're just going to put it up for auction, because they want it.
And there's some extremely limited exceptions to that, which the court discusses. But on the whole, the question isn't what is this worth after we've already eminent domained it. The question is what is the fair market value at that moment in time when this piece of property was
the government is saying we couldn't possibly calculate what the property is worth at the time of the taking, even though we already calculated what the property is worth because we assessed that value and we've been taxing you based on that value.
Yeah.
And by the way, the property taxes that you owed are based on that assessment.
Yeah.
So the government's now saying, we don't know what it's worth, though. It's like,
Total
how did you
doublespeak.
assess the value then?
I love that this is the most angry this panel has ever been.
I'm so mad. This case
we are
makes me
property
so
rights
mad.
lawyers.
Yeah.
On the whole, what we do is property laws. So this hits home for us. But I want to rewind a little bit because we haven't talked about the holding of the court yet.
Yeah.
Which is hard to articulate. It is hard to say what the holding is here. There are at least 6 justices that agree that the value is determined by the auction. So what price they get at the auction, that is just compensation. That's the value of the property. In a very we'll come back to that in a second. It is hard to say what the other justices believe, apart from, I think, did we decide 5 of the justices?
I think 6. No, 5. You're right. Yeah.
Right. Where the rest of the justices fall on that particular issue, because all of them agreed in the ultimate outcome of this case, which was a reverse vacate and remand. So they said, okay, judges, Sixth Circuit, there are so many unanswered questions about due process because, as we just explained, there were some really glaring due process problems in this tax sale. We're going to send this back down so that those due process issues can be answered.
Yeah.
And Justices Sotomayor, Gorsuch, Jackson, and Thomas all emphasize heavily, we're sending this back because these irregularities need to be accounted for, at least insofar as they are preserved. So you guys go deal with that issue. Justice Thomas has some slightly different feelings from the majority on what constitutes just compensation, and for the most part, Justice Gorsuch agrees with Justice Thomas. But let's start with what the majority says here and how we get to this conclusion. Nathan, you obviously disagree with it, but can you give your best steel man of what the majority said here?
So the question is what is just compensation? And so do we look at the value when before the sale, before the foreclosure, or do we look at value after the foreclosure? And what the majority says is that usually we're going to look at the fair market value, which is going to be the pre-foreclosure value. But in some situations, if the tax sale is conducted with due process protections in place, that tax sale can depart from the fair market value, and that's okay.
And the reason that's okay is because it comports with the history and tradition. So they don't want to use this conceptual understanding in order to override what they can see from the history.
And this is, I think, a case where originalism can depart from what we might like to see in protecting property rights, that even though we definitely all agree, I think that property rights should be protected and they get all the protection that all the other rights get, that if we look back at the founding, there were tax sales like around the time of the founding. And so we have to take that into account and how are those conducted. But we need to make sure that we have all of those protections in place so that when those tax sales are conducted and there is less than fair market value awarded, that it's been done in a way that's fair. And if it hasn't been done fairly, then maybe the government would be on the hook for that fair
That'd be a
market
due
value.
process problem, though, not a takings clause problem.
Right.
But it would also bear on the originalism that
Yeah.
is informing the takings,
Yes.
like the extent to which is useful evidence of how those sales were conducted.
So the majority says that as long as you have those due process protections in place, that the auction value can take the place of the fair market value and for just compensation. That's what the majority is saying here. But it's a bare majority of, even though it's a unanimous opinion, only 5 justices fully embrace that that this was probably okay.
And I think it's important to talk about why the majority does talk some about the kind of original public meaning, and tax sales are very old and we've been doing this for a long time. But in some ways, the crux of their argument comes down to this sentence. This is from the majority opinion. Pung's fair market value theory would impose unprecedented burdens on jurisdictions that wish to collect unpaid taxes and might well make tax sales impractical. There's several pages in the majority opinion dedicated to just how impractical it would be to require the government to take on the burden of using the actual fair market value of the property.
Yeah.
You'd have to have some sort of person come in and determine the value of the property. You'd have to have somebody put it on the market. You'd have to have real estate agents.
They're taking
You'd have to have
all the liability that is associated with
all
that
of the
property just to try to
liability.
get their taxes back, which
right.
are owed to them.
Right,
Not in
which,
this case, but yes.
like, I have some sympathy for that. It would be unwieldy for the government to have to employ a fleet of real estate agents whose job it is to, prep these houses and put them on the market. And if it's, we've assessed the market at 194, but nobody's bitten for the last 2 months. So can we go down without having to, as the county, pay out of pocket this $2,000 or whatever that we've decided to go down in price so that we could maybe get a buyer? What do you do if the market suddenly changes and now all of a sudden that house that you appraised last time at 194 is now only worth 187? What are we supposed to do?
Yeah.
Those practical considerations are very much at play.
However, it's like the world's smallest violin playing for the local government that's been trying to seize excess value from people's homes for tiny tax bills, right? It's
they're motivated to take those properties up until Tyler v. Hennepin County because they get the extra 15, 25.
Yeah.
In some cases, this one was $74,000.
So instead of taking a car or a motorcycle or something else that would be closer to the value of the tax bill actually owed, they end up taking the largest asset that you own.
Yeah, right.
And just because they wanted to gobble up that excess value.
Yeah, and just like pilfer the wealth that's in it for themselves, but not take on the liability associated with owning it.
And that's one of those historical factors that Justice Thomas talks about in his concurrence. He points at several different boundary lines that used to be placed on the government before they could commence a tax sale like this.
Yeah.
And one of those boundaries was you have to go after personal property first.
Yeah.
You have to try to satisfy this debt with the debtor's jewelry, for example, or their car, or their horses, or, those other things, because you don't want to leave these people homeless for a $2,000 debt.
Yeah.
But that's exactly the world that we're living in right now.
Yeah, like, hey, you can't just use the existence of tax sales in history to like categorically excuse any manner of tax sale.
We can do this however we want to because it existed in the founding era. Like, that's not how this works.
It existed in a particular way that was, as Thomas sees, more protective of property rights than what the county did here.
Yeah. There's a great line. Justice Thomas really comes out swinging on this one. He says, property is a natural, fundamental right. And he's quoting himself in Kelo versus City of New London. He's quoting his own dissent.
Never forget.
This man is carrying a torch, and he will carry it till he dies. Property is a natural, fundamental right.
I'm here for it.
Yeah.
And if we assume, like we were talking about earlier, if we assume that this is every bit as much a right as the Second Amendment or the First Amendment, then this case should be easy to a certain extent. You have to protect it, just like you would protect guns, just like you would protect speech.
Yep.
Yeah. I think he also says the government exists to protect that natural right of property. not the other way around.
Yes.
Property doesn't exist to like, support the functions of government.
Yeah.
And that's not just us like importing Locke, even though we love John Locke.
Although
if
you do have to watch us because we might do that.
Yeah, we do. It's true. But if you read cases like Van Horns-Lacey versus Dorrance from 1795, it literally says that's the purpose of why we created local governments was primarily protection of private property.
Yeah.
That's what you see in cases like Calder versus Bull. That's what you see in these early founding era cases where they're talking about what the nature of the social compact is. You don't have to look at John Locke. You can actually look at what our founders wrote. Yeah. And I think from an originalist perspective, that should matter.
Justice Thomas's response to this sort of parade of horribles that Justice Alito lays out, but this would just be unworkable, unwieldy. Municipalities would never be able to collect on tax burdens. His response is, he's addressing the county's argument. The county's response is that if it is not able to take people's homes and sell them at auction in the manner that it did here, it will not be able to efficiently collect taxes. It argues that a fair market value rule would impede the government's ability to foreclose on homes in order to collect delinquent taxes. In my view, that is the point of the Takings Clause, which necessarily prioritizes homeowners' property rights over the government's interest in efficiency and public necessity. William Blackstone wrote that the law of the land postpones even public necessity to the sacred and inviolable rights of private property. And again, he's quoting himself in Kelo. He says, the government exists to protect property. Property does not exist to support the government.
Mm-hmm.
That's my dude.
It's a mic drop moment.
Yeah. And that's good originalism too. It's not, it's not just importing Locke. It's William Blackstone. I mean,
Yeah, this isn't just some ivory tower perception of what our Constitution is supposed to do. It is our Constitution.
Yep.
Mm-hmm.
This is how it actually works and how it actually functions. So, to the best of your ability, Nathan, do you want to give us a scorecard?
9-0, the court decided unanimously that the fair market value of the house, at least for this, is not going to be relevant. We're going to look at the tax sale for the purposes of determining just compensation under the Takings Clause. But much narrowly, the court fractures on what due process requires for that auction. And so that's potentially still going to be litigated below. Believe it or not, this case has been going on for 16 years, and it's only up on a partial summary judgment motion, meaning that this is going to go back to the Sixth Circuit, and then after the Sixth Circuit decides, it could go up to the Supreme Court again, or it's at least going to go back to the district court for the rest of the claims that have not been adjudicated on this. So the Pung's ride on this is not over 16 years after this process began in Michigan. But for the purposes of this case, they at least can't claim that Michigan owes them the $194,000 that they, or the $195,000 that the property sold for.
It might turn out to be the case that if they do the auction properly, that they might actually get the fair market value from it and be owed that.
Yeah, so what could happen is that the lower court could decide that due process was not followed, and that because of that, then they're going to have to assess some kind of penalty against the government or force them to pay more compensation.
And just think about the years and hundreds of thousands of dollars, at this point probably approaching $1 million in attorney's fees, that the government has spent to get a $2,000 tax debt that the Pungs did not even owe. Perspective, people.
Well, it's not about the tax debt. It's because they want to keep doing this. They want to keep enforcing their law their way.
Yeah.
And something that we maybe lose sight of a little bit more than in other areas of law is the human impact of public interest litigation like this.
Yep.
And it is so important for us to bear in mind that justice is reserved for those strong enough to withstand the process. And the process is long and arduous and painful. And it is heartbreaking for these people that their battle is not over.
Yep.
I mean, they're still alive to fight another day. This case is still live, and it didn't have to be after this. The court could have shut them out, but it's back in the Sixth.
And we've had cases like that where we've gone up multiple times, and that case drags on for 5, 6, 7, 8, 9 years because the first 3 years we're just arguing about whether or not you get to get into court in the first place.
Yeah.
I think we can't keep people from being people. And we say, kind of jokingly, you don't hate government enough. But it's there's people that are running government, right? And a lot of them maybe most of them, maybe the vast majority are good people, but people are going to be people, and there's going to be people across the spectrum. It doesn't matter if you look at government or any other sector of society. We can't keep them from being people. And so the founders knew that, and they put limits on government that keep, when people want to act badly or they want to extend their power and extend and do things that they really shouldn't be doing, that the government can't do that. It's not about, we don't have to look at what is the motive of the bureaucrat like this tax assessor in Isabella County. It doesn't matter, because government can't just take someone's property without due process and without just compensation. And so we need to make sure that people are, when people are being people, that the structure of government, the structure of our rights are protected, so that whether it's the Fifth Amendment or the Eighth Amendment or the First or Second Amendment, that those limitations on government are enforced. Because when you start watering down enumerated rights, then people in government are going to continue to extend their power and get bigger and bigger and bigger, and it makes everyone's rights, everyone's property rights, and every other right get smaller and smaller and smaller.
And it's just a reminder to judges out there that, like, this is one of the reasons that when the government says, oh, we have a legitimate government interest for this, or this is a nuisance, or something like that, that the court shouldn't just accept that like a rubber stamp, because sometimes government be crazy.
The whole point that they're an independent, branch of government is they don't have to believe them if they don't want to.
And we as individuals have to be jealous of our own liberties.
Yep.
We have to be ready and willing to fight for our own liberties, because the government is not here to protect them for us. It's not. They're the ones who are going to take them from us, not the other way around. So, all right. Well, thank you, Nathan. And thank you guys for joining me today. And for our listeners, if you've enjoyed our conversation today, please leave us a review. Tell us what you think about all of us getting up in arms about property rights. And join us next time for more Rightly Decided.